All right, let's be on the record in case number 2020-CR134, captioned State of Kansas versus Gary Winters. Would the parties announce their appearances, please?
May it please the court, the state of Kansas appears by Assistant District Attorneys Kayla Rayler and Garrett Ralph.
May it please the court, Your Honor, Mr. Winters appears in custody and by video with counsel Chris Scott, also by video.
All right, we are here set down two separate motions. The defendant filed a motion for substitute of counsel, followed by counsel filing a motion to withdraw. So I think, Mr. Scott, you can probably address both of those, and then I'll talk to Mr. Winters about his desires.
Yes, Judge, and Mr. Winters had filed that motion a while back. Within a few weeks of that, I had met with him to talk about his concerns and the issues in the case. And there was obvious disagreement on things, but after my meeting with him, I went ahead and filed a motion to withdraw on the matter.
All right. And the basis for that motion?
Judge, the basis for the motion is that I do believe the communication has broken down to the point where I can't effectively represent him, Judge, and there are some issues on not just trial strategy, which is more the attorney's call, but just trust, and if I have his best interests in mind. And like I said, even if I disagree with how Mr. Winters interprets things, I mean, you do have to have faith and trust in your attorney, and I think we've lost that for whatever reason, and that he no longer wishes to effectively communicate with me, and he would desire a new attorney. Mr.
Winters, do you agree with that?
Yes, sir.
All right. State what's your position.
Judge,
I'm sorry.
If Mr. Winter wants to speak,
No, I thought he was talking to me. I'm sorry. Go ahead.
Yeah, I'm sorry. I was asking the state. Yeah.
Judge, generally the state doesn't get involved in attorney-client matters. If it is an issue relating to trial strategy, obviously that's Mr. Scott's call. Mr. Winters has the right to an attorney, not the right to his choice of attorney under the Constitution. If he is getting an appointed attorney, if there's a disagreement of trial strategy, I think that goes down to what the attorney wants to do at trial.
All right. So, Mr. Winters, I guess the long and the short of it, you would like me to substitute counsel at this time. Is that correct?
Yes, sir.
Okay. The victim advocate is now waiting to come in. I'm going to let them in. Maybe it was them beforehand, but the record should reflect the DA's victim advocate is joining the hearing. All right, Mr. Winters, look, here's the way I look at these things. And I don't think it is trial strategy, because frankly, we're so far from getting a trial set that I can't imagine that there's a lot of planning going around at this point as to how to approach that trial. This is kind of my own educated guess, having been both a prosecutor and defense attorney in the past, that it's probably a disagreement as to whether there should be a trial or not. And certainly that is the final decision is that of the client when it comes to whether to take a plea or whether to go to trial. So look, this is an important case to everybody, to the alleged victims in this case, to the defendants, obviously. So I don't see a prejudice to either side at this point. If we were 1 week from trial or even 1 month from trial, then I'm going to hesitate greatly to delay everything for that. We're nowhere close to trial, and who knows when we will be. So I don't see any prejudice to anybody to letting a new lawyer in. So I'm going to grant the motion. I'm going to let Mr. Scott withdraw, and I'm going to appoint a new lawyer to Mr. Winters. Now, with that being said, Mr. Winters, there's a couple of things that I want to go over with you. This is speculation on my part, and if I'm wrong, you can ignore everything that I'm about to say. I heard the preliminary hearing in this case. I want you to know this. If you tell a lawyer that you are not going to take a plea that you want to go to trial, regardless of what they think, the lawyer who is worth their appointment, and that's the only kind you're going to get, particularly in these kind of cases, would do everything in their power to represent you zealously and completely at that trial. But if you are looking for a lawyer that you want to say to you, look, I've reviewed the evidence, I've reviewed the preliminary hearing, I've seen all this, I don't think you should take a plea, and I agree with you that you should go to trial. Look, somebody may come to that professional conclusion. I don't deal in whether you did it or don't, unless and until you ask for a trial to the court, to the judge. That's not my job to figure out whether you did what you're accused of or not. That would be the jury's job. But what I do think I have to deal in is strength of the evidence. All right. That's a whole different thing from whether I believe you did it or not. The question is, what is the strength of the evidence? If you get a lawyer and you want to fire that lawyer because the lawyer says, I've reviewed the evidence in your case. And particularly in this particular case, I would assume that a good lawyer is going to, because I want to give you the ability to kind of assess your lawyer's ability, is to talk to you about the fact that this alleged crime was caught on video.
Mm-hmm.
Talk to you about the alleged fact that your DNA is alleged to have been the blood trail that appeared to come from the person who was shot in the leg during this video of this incident. That you were allegedly found in a hospital with a bullet wound that matches that. And I don't recall right now if that ballistically matched the victim's gun or not. That allegedly the person who was with you at the hospital was found on a bus with a video showing that the seat that he was on had a gun that ballistically matched the bullets casings from the scene. All right. So if you don't have a lawyer who is specifically talking to you about the strength of the case, then they're not doing their job. And look, I'm not saying in one way or another, I have no idea. You may have the greatest defense in the world, and I'm not saying you don't. But if the reason you're firing Mr. Scott is that you don't like the fact that he's confronted you with all this and given his honest opinion of what your chances are at trial, I need to caution you, I can't let subsequent lawyers come and do that, because any lawyer that is doing their job is going to have to discuss that with you and give their honest opinion as to what the likelihood of you winning at trial, what you're looking at as far as a sentence goes if you lose at trial, and discussing with you the ins and outs of a plea. Now, at the end of the day, if you listen to all that, you hear all that, and you say, I have a constitutional right to a jury trial, I am maintaining my innocence and wanting to go to trial, absolutely you should do that. But if the reason that we're here today, that you're not wanting Mr. Scott, is because maybe he spoke with you about the strength of the state's case, I'm going to let him out because it's your first shot and it's not hurting anybody right now. But if this comes across that way, I can't let subsequent lawyers out if you don't like what their assessment of your case is. Look, I think I've said enough. So, and you know what, I urge you not to respond to that, because I don't know that, I don't want to feel like I set you up to say something that's going to come back to haunt you later. So I'm allowing Mr. Scott out at my soonest opportunity, which is probably going to be today or tomorrow. I'm going to find another lawyer. And let me tell you this, I gave Mr. Scott this case because he is a lawyer that is has the experience, competence, and diligence to handle my biggest cases. These murder cases are the biggest cases. You're going to get another lawyer that I also think is diligent, competent, and experienced enough to handle your case. So I want to assure you of that. I expect that you will work with your lawyer to the best of your ability, and understand that they have an ethical obligation to discuss with you honestly their view of the case. Look, like I said, I defended a lot of people. I didn't have a problem going in and telling a guy, I think the state has a great case against you and you are in grave danger of being convicted if you go to trial. However, if you decide to go to trial, I'm going to fight like with all my capabilities, just as if I was completely convinced of your innocence. That's what defense lawyers do. Okay. So if a lawyer tells you, I think the state's got a really strong case, do not hold that against the lawyer. I think if that's their opinion, they would be remiss if they didn't share it with you. And it doesn't mean that you're not going to get their best effort at trial if it happens.
Yes, sir.
All
I
right.
understand that.
All right. So we're not set for anything right now. We're just waiting for jury trial settings. Is that correct?
May I say something, Your Honor, if you don't
Sure.
mind?
Okay.
And I'm just being honest with you. It was more than just about the trial. It was, things that have been said and things that
All right.
went outside.
Sure. Look, and I don't want to get into that. I understand, and I'm granting your motion today. I don't really have a position or any knowledge, nor should I have any knowledge about what your conversations with your lawyer are. All right. This case, was it mediated?
Yes.
You're muted. It was.
Sorry,
Okay.
it was.
So we're just waiting for a jury trial setting.
Yes, Your Honor.
All right. And by the way, somebody named Randall Briggs, who I'm assuming was RAB, was trying to get in, but I didn't let him in. Can someone
Yes.
advise me who that is?
That is the victim's father, Your Honor. RAB was actually Rashana Biggs, who is the victim's mother. She was at
Okay.
work.
Can you advise them of what occurred?
Yes, Elaine, my victim advocate, will do that in the future. We'll try to make sure that they just do the YouTube link, so we're not trying to figure out who these people are during the
Sure.
hearing.
And if they want to be here, that's fine. I just
Yeah.
need, like I said, I couldn't get an answer out of that person, so I wasn't comfortable having them in. All
No,
right.
I agree.
All right. So we're just waiting a jury trial setting. Anything else for our record today?
I don't believe so, Your Honor.
No, Judge.
We're adjourned.